Okay, so hi guys. So this is the follow-on video from Taylor Swift's motion to dismiss. It's not long. There's 2 documents that have been filed, a total of 5 pages. So we should get through this really quick. Okay, so this is Maren. I do use Maren Flagg because that is, who knows, that's the name that the lawsuit is in. So this is Maren Flagg, also professionally known as Maren Wade's notice regarding defendants' non-compliance with Local Rule 7.3. Plaintiff submits this notice to direct the court's attention to a matter addressed only in a declaration accompanying defendants' motion to dismiss. Defendants concede they did not comply with Local Rule 7.3. As their counsel's declaration states, defendants were not able to conduct the meet and confer 7 days prior to the filing of the motion. The parties conferred on May 22nd, 2026. 7 days later was May 29th, 2026. Defendant's deadline to respond to the complaint was June 2nd, 2026. Defendants nonetheless filed on May 26th, 2026, the day before the May 27th, 2026 hearing on plaintiff's motion for a preliminary injunction, which has been on calendar since April 7th, 2026. So there's a hearing today about the motion for the preliminary injunction. And what she's saying is there is, as under the rules, you have, Taylor Swift has to meet and confer 7 days before filing a motion to dismiss. They conferred on May 22nd. And then that which then they are supposed to not file the motion to dismiss before May 29th. But they didn't wait for the 7 days. They filed 4 days later, the day before the hearing. That's kind of the crux of what they're saying. Hold on a minute. They haven't adhered to the rules. As their counsel's declaration explains, defendants filed when they did so that the court would have the benefit of the motion to dismiss prior to the hearing. Plaintiff objected to the timing during the conference and in the correspondence defendants have attached to their motion. Plaintiff submits this notice so that the matter is before the court rather than addressed solely within defendant's supporting declaration, and respectfully leaves the appropriate disposition of defendant's non-compliance to the court. Nothing herein waives, and plaintiff expressly reserves all rights, including the right to oppose the motion on any ground and to amend under Federal Rule of Civil Procedure 15. Okay, so bear with me. What I will do actually is just quickly go back to the motion to dismiss, because I didn't see the declaration. No, I didn't see a declaration actually, so I won't go back. We'll go to the other file document. That is not on. It's not on Court Listener. It's on Pacer. So let's have a look. Okay. So this is an order on defendant's unopposed application for leave to file under seal. Okay. On May 6th, defendants filed an unopposed application for leave to file under seal certain information contained in the declarations of Joshua Dobler and Joseph Schmidt in support of defendants' opposition to plaintiff's motion for a preliminary injunction. Of note, plaintiff's counsel agreed to the styling of the application as unopposed, but also stated plaintiff reserved all rights, including the right to oppose or otherwise respond once plaintiff had an opportunity to review the application and materials sought to be sealed. To date, no opposition to the instant application has been filed with the court. Courts of this country recognise a general right to inspect and copy public records and documents, including judicial records and documents. As a result, a strong presumption in favour of access to court records exists in civil cases. However, this presumption in favour of access must be balanced with a court's supervisory power over its own records and files. In general, a request to seal a judicial record or document is subject to a compelling reasons standard or good cause standard. Where the documents sought to be sealed are tangentially related to the underlying cause of action, the court applies a good cause standard. Otherwise, applications to seal judicial records are governed by the compelling reason standard, which provides for the right of access in the civil context to be overcome if sufficient compelling reasons are given for such action. Upon review, the court concludes the compelling reason standards for it. Under this standard, the party requesting the sealing must articulate compelling reasons supported by specific factual findings that outweigh the general history of access and the public policies favouring disclosure. For instance, compelling reasons have been held to exist in this context where court files might have become a vehicle for improper purposes, such as the use of records to gratify private spite or promote public scandal, circulate libelous statements, or as sources of business information that might harm a litigant's competitive standing. Yet the mere fact that the production of records may lead to embarrassment, incrimination, or exposure to further litigation will not, without more, compel the court to seal its records. Indeed, a court's decision on whether to seal specific judicial records must be based on a compelling reason and articulate the factual basis for its ruling without relying on hypothesis or conjecture. Here, the declaration of Catherine Wright Morone and review of the unredacted declarations at issue support that compelling reasons exist to the limited sealing related to the non-public financial and strategic business information contained in the respective declarations of Mr. Dobler and Mr. Schmidt. Accordingly, the court, having considered defendant's unopposed application for leave to file under seal and related filings, and finding good cause, therefore, hereby grants the application and orders as follows. Defendants may file under seal the unredacted versions of declarations of Joshua Dobler and Joseph Smith in support of defendant's opposition to plaintiff's motion for a preliminary injunction. And 2, redacted versions of the 2 aforementioned declarations shall remain publicly filed on the docket. Okay. So that was nothing exciting. It was just, you can file an unredacted version under seal. There's nothing to see there, but we'll see what happens. The hearing is not something I can telephone into, so I will have to wait and see what happens with that. I'm obviously not going to be attending it because I'm so far away, but something will be posted at some point and we'll find out what happens there, or we'll hear by an order on whether the preliminary injunction is granted or denied. Okay, guys. Let me know what you think of this, though, and I will just see what happens, and what they do with this motion to dismiss as well. They're obviously it's not going to be a ruling on it at the hearing, but because there's a right of opposition and then a right of reply. But it'd be interesting to see if there's any transcript that kind of goes through it.